Representative Levesque to get here, so.
And call this a quorum. And my name is Representative Bickford, and this is Representative Moulton. And so we're here for HB 618, which is relative to wage garnishment with child support payments. Do we have anyone that wants to speak to this bill at this time? Okay. Very good. Then it's you and I.
Okay.
I don't know if you had a chance to look at it very much. It does break down into really two sections. You have your first section, which to move from your 2 months, which is now 1 month, in order to be in arrearage, would trip some federal.
Is that what we had said at the last committee meeting in March? Because I don't recall that.
Well, presently the system is 1 month.
Oh, I see.
Now for
Okay.
an arrearage. The bill asked to go to 2 months to create an arrearage.
Okay.
Which ordinarily I don't think I'd have an issue with it. However, it does trip these federal issues, which our researcher has dug up for us.
Okay, so let's
Title
table it.
4D, Social Security Act of 75.
Okay, so I just want to take some notes. So currently, RSA says 1 month. This would go to 2 months. But then there's possible that it could interfere with federal law,
Yes.
and we can't do that.
Well, we can, however, if you look at the analysis on the back page, it'll trip all these possibility of losing federal funding of 13.6 million of federal funds, and then $1.2 million of incentive funds and 1.9 million of TANF law grant funding.
So those would go to the individuals who are in arrearage?
No, this would be to the state. The state funding could be reduced.
Okay.
And the reason I know this because I dealt with wage assignment in the past, and they brought in and we didn't like the new laws they were coming forward with, which was because it was mandatory. And they came up from Boston and said, you do this, we're taking 21 million from you. Now, I think it was 20 months, the whole thing.
But what does the state do with that money?
Run their operations.
So we don't want to do that.
A lot of the child support system is funded 2/3 by the federal government.
Okay.
And and New Hampshire puts in the third.
How would federal? Oh yeah, she emailed us this. I guess my question is, if this is going to the state, but it's blocked because we changed this, what is the state doing with this money that we would no longer be able to do because we wouldn't get this money?
I think you'll find their computing systems depend on this money, I believe, as well as enforcement, probably their attorneys, some of it. But the federal government has the right to reduce what they give them because they're out of compliance now with federal law.
Sure.
If we go to 2 months.
Right. So then that makes me think that we shouldn't do that.
Okay.
What do you think?
I agree with you, at
Okay.
this point anyway.
So we're gonna,
I mean, I have my philosophies but I don't think this is the time or place to do it
sure,
in there. However, moving to the second part, which is here
okay.
in paragraph 3,
Mm-hmm.
they're talking about creating a standard form to enlighten people about what they can do, because we have it in the law, but apparently people aren't being told this is the law, and not everybody has an attorney.
I recall that from March, yeah.
Okay.
Yeah.
Which sounds good to me.
That does sound good.
Um,
So, and that's why we retained this, was because we wanted to, I recall this now. Because we wanted to change a little bit this, so we want to keep this as the 1 month, but we want to keep this part because this was good.
Yeah, and we ordinarily, with a lot of things, we have done that in the past. We've told them to enlighten the public as they come in. And
Right.
so I was surprised to find that this didn't happen.
Yeah. So can we get them, isn't that a process that they can draft that now? To change this part to,
Yeah, we could just have them remove 2. Leave it as is. And then
Right.
this would be a new paragraph added. That would be an amended one here, I believe.
so does that come to you, Christina? Are you the one that drafts this to,
No.
okay, do
Yeah,
we have to take it down
Let's go
to
downstairs and we'd bring back an amendment.
an amendment?
Yeah.
Okay. Or can we email it to them? We can email it to them, okay. Sure. Okay, so what we want to do.
We just want to make a recommendation
we
to
want-
the club,
Sure.
other
that-
members.
Right, and that's fine, because we can do that at the executive session. So what we want to do, we want to remove section 2.
Yep.
About income assignment. And we want to keep 3.
Yeah, they'll have to make a little changes because this is,
Oh.
we don't want to say final divorce because it's not about divorce. It's about children.
Sure.
Um,
Right,
So-
and not every situation is a divorce. It's just a
Exactly.
child support, right?
Exactly.
Um,
So I put down by or before final, or
that's in
it could be
3.
final, I guess, or it could be hearing.
3IA. Change
By, yeah. At
at
least
the final.
during the process, and I am not sure where the process begins and ends
To
for child support. They have referees
Okay.
now that help. Wait to get done.
to buy in before hearing. Okay. But this part, everything else was good here. If they take all of this out, then this is all
Yeah, I
okay
think
up
number
here.
1A would
Oh, 1A.
probably say, but they'll know what to do.
Okay,
I
they
mean,
should
like,
just
this is-
remove the word divorce.
Yeah.
Yeah.
Because this is the notification, it says, the court shall notify each party of their income assignment wages
Right.
for child support will be automatic under the RSA unless both parties come to an agreement upon
Another
another
arrangement. Right.
arrangement. And
Sure.
then you go right down here,
Income assignment.
the Department of Health and Human-
Division of Child Support Services shall develop a standard form. Right.
That's kind of interesting, how they did that.
Uh-oh.
See, that's 1A.
Do we want
1A.
this to change to be, instead of Health and Human Services, Bureau of Child Support Services?
I think that is correct.
Okay.
Because they come under Health and Human Services.
Oh, okay.
I think division is,
Okay. I don't know that.
they
Okay.
should know.
So let me just write the question. Where was that? Here. If 3 should say Bureau of Child Support Services instead of Health and Human Services. Okay. And then that's it, right? What was it?
Yeah.
What did we want down here?
Well, it's interesting because that's me really. It says,
Uh-huh.
this amendment conflicts with federal 45,
Oh,
the one that we talked about, 100, which we have.
right.
which is up here in number 2 that we're eliminating,
Uh-huh.
which states that the income of the non-custodial parent
This is-
shall become, which is
This is what
interest-
flagged us to
well,
need to
it-
put it to
it-
subcommittee.
It demonstrates what happened in the past. It hasn't been corrected, as far as I'm
Oh.
concerned, at the federal level,
Yes,
because they're still calling people non-custodial parents.
right. And we don't do that anymore.
Right. A person that pays is
Is the pay.
support
yeah,
would be considered
obligatory.
non-custodial.
Oh,
which,
yeah.
Which I always, it's a great offense to, because it means, in a sense, you're not really a parent.
Yeah, and it
If you
has,
don't have
someone
custodial
has to
rights.
pay. So, you
Yeah,
know, but
well,
both people
not-
should see the child. So,
Yeah.
Oh,
But we've come a
down-
long way, and a lot of people don't think so, but we really have. In,
this all methodology part though, this part all in the, this isn't in the,
Part of the bill.
Right, but does it go into the RSA?
no,
Right, okay, this is just for our
yeah,
information.
it would stop.
Right, okay,
Yeah. Of course, effective date goes at the
Sure.
tail end, then you don't know what part get added.
Right.
Unless you're
okay.
better at
So I
bookkeeping than I
can
am.
send, and I'll send you, I'll CC you to it. So OLS, CC Bickford. Amend House Bill 615? What are we on? 615? 618.
Yeah.
618. Please make. And I'm just gonna do exactly what we have here. Changes to 618. So to 1A. Move or divorce. Section 2 entirely. And then 3IA, change at the final divorce hearing to by and before hearing. Thank you. Right.
Let's see, move board. All right, please make the following changes. You want to, okay. Yep. Remove section
2.
2 entirely, good.
Oops. What just happened? That's weird. Okay.
And
Pop-ups.
3, or you want to,
3-1A. 3IA,
why don't
whatever.
you,
We wanted to change.
if you want to name it, just a consistency, section 2, remove, 3A, change.
Right. Good.
Call that section 3. Comma after the 3.
Is it?
Well, it's 3 and then it goes to
Yeah.
I.
So
I think-
3IA.
I think you usually throw a comma in.
Oh, I don't know.
We can always check with them. IA dash A. We got plenty of time.
Yeah.
Change it. Okay, you've captured it.
Is that all of it?
Well, I put down standard form because I don't know why it needs, if it's just a form. Doesn't need, do we need to tell them it needs to be standard?
I think
So, but okay.
I think just
I was
standard
hoping
form
that-
meaning goes to everybody.
Why don't you, can you CC Matt Hayes? Do you have his address over at Child Support? So they know what we're thinking?
No. I don't think so. I only have who comes up in the
In your email thing.
right.
Christine would know. You want me to get it from her?
Sure. She'll come back.
She will?
Yeah.
Oh, you're confident.
She always does. She just stepped
You
in.
told me Rebecca was gonna show up too.
I know.
You said late though, so that could be most any time, right?
Right? Matthew Hayes is who?
Well, he's the child support attorney that comes here.
Oh.
That's been assigned to the legislature.
Got it.
There's also Susan Brisson, who he works for. And then, of course, there's the
Yeah, I should get his
Lisa,
email
is it
address.
Lisa, Lauren? Lisa, I think. The woman that runs the whole thing.
Mm-hmm.
But we
Yes.
ordinarily would use Matt Hayes. Yep.
Oh, I'm sorry.
Oh.
Sure, no problem. So, because the current bill.
Excuse me, do you need to see the bill, or you got it in front of you now? Okay, good.
Okay, so the way the current bill is written, it conflicts with federal law, and it would deny, and that's what he was explaining to me in the beginning, that that there would be a conflict with federal law, and that would prohibit some state funds from coming in. So so what we wanted to do, and this is the whole reason why we retained it in committee, was because we wanted to fix these little issues. So what we want to do is remove section 2 entirely, because switching it from, it's currently 1 month. If we switch it to 2 months, that's when we start this conflict with federal law. For section 1A, so I'm a little out of order, but it's just a wording issue where we just want to fix the language.
3-1.
No, I'm up here.
Oh, you still are up there?
Yeah, so 1A. I'm sorry. We just want to just take out the word divorce in divorce hearing, because not every child support hearing goes in line with a divorce. Like it could, and it frequently does, but there can also be like engaged couples that break up, or boyfriend girlfriends that break up. And then down in 3-1A, again, it's more just a language thing, for the same rationale as 1-1A. We don't want it to say final divorce hearing. We want it to say by and before hearing, just because it might not be a divorce situation. And we don't want there to be confusion as to, you know, if someone was in like a boyfriend girlfriend and they need to get child support, we don't want them to be like, oh, they don't fit under this law because it's not a divorce. So we just want to clean up a little bit of language.
But that's about creating a form to inform people of their situation
And-
under this wage
Right.
assignment.
And so that's why instead of just voting the bill down last spring, we decided to retain it, because these were just a few like minor little issues. So yeah, of course. So, but the process, I guess, is that we have to get OLS to amend it and then present the new amendment.
Yep.
But that was what we were going to decide to do. And then what did we need Christina for? She's back.
Christina, do you have an email address for Matt Hayes, and we'll send it over to child support through him, because he's the one assigned for this committee. Do you know who I mean?
I don't have his email address.
We want to send him what our intent,
I'm just wondering if you have his email address so I could send it to him.
because we're going to send this to OLS, the changes we want, and then at the same time, we'll send it to the Bureau of Child Support Services through Matt Hayes. And
Yeah, that'd be
That way
fantastic.
we keep everybody in the loop that we can think of.
And this is why I bring my computer to these. So. And then
So you
once
said-
I get the email from her with his email address, then I can send this to OLS. We can have it drafted, and we'll have it ready to go to present to present for executive session. And that's essentially it. Did anybody have any feedback? Do you have any feedback? Do you have any other recommendations? Okay.
All right, we need to fill out our form.
Yep, I have that here. All right. But we're not doing anything.
Yeah, we're going to do a, ought to pass with amendment.
amendment. Adoption of amendment being drafted.
Yeah.
Thank you. J. Hayes. Matthew Dodd. Okay, perfect. All right. So I sent that. All right. Changes to language in sections 1 and
Just
3.
disappeared.
Oh yeah, because it's sent. So it's not in a draft anymore. Because I sent it.
Oh, you did? Oh,
Yeah.
okay.
I have a setting on that it delays my sent items
Oh,
for
is
like
that right?
10 seconds.
Probably a good
So
idea.
that if I have like, oh, I wanted to add something, I
Yeah.
can just undo it
Yeah.
and then add
Oh.
that last like thought that comes in after.
Geez, I may want to.
Yeah, it's actually not, it's a good feature to have.
Yeah.
So that I can undo things. I only have like 10 seconds to do it.
Yeah.
But if one more thing, then I don't have to send multiple emails.
I better do about 5 minutes.
Changes to languages in sections 1 and 3, and then remove section 2. All right, so we have a motion that this will be ought to pass once amended.
Yeah.
Okay, so moved by Representative Moulton, seconded by Representative Bickford.
Yep.
Okay, and then we will adopt a motion to be adopted at exec session later. Good?
Yeah, we'll just take a vote, between you and me. Make the motion to amend it as you wrote it, which is in your,
I do
it's
that
in an
now.
email now.
Right, but we have to get the amendment back so that I can put the amendment number. It's currently being amended.
Well, you already said we did a motion.
Well, we kind of did.
That's why I just think, well, maybe we should make it official.
Currently being drafted by OLS. Good? Because I don't have the amendment number yet. So we can't adopt an amendment that we don't have the
No, you
amendment
can
number.
speak to what, just say what you, could you say, want to pass an amendment?
Yeah, you told me to.
You said move by Representative Moulton. What are you moving?
That we're going to pass it, we're going to ought to pass it. We're going to make a motion to ought to pass with amendment once we get the amendment back. But
And
we
the-
are
and the-
sending,
And the amendment will remove
remove
section 2.
section 2, and we're changing language to sections 1 and 3 that I read out loud.
Good, okay. I will second that.
Okay, perfect.
All in favor?
All in favor? Aye.
There you go. Now it's official.
There we go. Subcommittee chairman. I guess that's you.
Did you get her, did she get you that one from Matt Hayes?
She did.
Oh,
Yep.
okay, I didn't.
Yeah. Yeah. I said, hey, you want to sign it?
Yeah.
Because you don't have a forum, you guys cannot recommend, I mean, you can put it in an amendment if you want.
Well,
but
we're
you
just
cannot
filling
make-
this out.
Okay, but you can't make a formal recommendation, you can't
Oh, okay.
do that because you don't have a forum.
We do have a quorum. We've got 2 out of 3.
You technically have 4 because Representative Eastbourne is on the committee.
Oh, she
so
is?
you do
I
not
believe
have a quorum.
she was supposed to be
I
taken
called
off.
Representative Pearson, she is still on the committee.
Oh, no.
So unfortunately, you do not have a quorum. That does not mean that you can meet at any time between now and the executive session, even if it's half an hour before.
Okay.
But you can't make an official, recommendation if you don't.
Okay.
Um,
Well, I just, in that case, I'm gonna
Okay.
forward this to
So you can still,
D. Simone
you can still,
and.
yes, but
We
it's
can still-
okay to forward, but she couldn't reply to you because, that's I don't know, depends on if you're forwarding to everyone, so.
I'm not, I'm just sending it to
Oh.
those two.
Um,
We still need the amendment.
yes, you can still make the amendment, but
Okay, what do we do with this then?
you just need to,
Hold
wait
on
till
to
you
it?
get a quorum.
Do what?
Okay.
You have to wait till you get a quorum. You could even meet, like, when he makes a, executive session,
Yeah, yeah.
you could meet half an hour ahead of time and decide that.
We made this out. Does that mean we should not make it out?
I think it's okay, but you cannot recommend OT.
Okay, see, I made you do all that stuff for
So
nothing.
no decision making.
Talking about-
You can keep it, hang on to it.
Oh, really?
But,
We don't turn it into you?
well, you can't because you don't have a quorum. You can't make that recommendation.
Yeah.
You need a quorum to make that recommendation.
Okay, we thought we had a quorum because
So-
we thought that D. Simone was taken off, so we thought we had 2 out of 3.
No.
Okay.
No, so,
Yeah, that was my impression too.
hang on to it
Okay.
and, if and when, so I don't know, I think there's a full, having a full committee, children and family law session at some point. I don't know.
Well, I don't think it's scheduled yet.
So.
Yeah, sometimes it's not till like December, I'm not
Yeah,
sure
so,
what they did.
well, no,
'Cause we don't
November
vote.
17th is,
whole-
is the report
whole
update,
committee?
so it will
Oh.
be in the next.
Oh, okay.
Of this,
That's fine.
of October?
No, November.
Okay,
So, and then, you'll have a little bit of time, so you could do it anytime between
Sure.
now and before the executive session to
Yeah.
make that full recommendation, but feel free to get your amendment, but you just can't.
Perfect.
well, you mean to have another meeting or?
Like a mini meeting, I guess. But that's why I'm emailing it to them so they can at least read it and review it.
Yep, that's, as far as I'm concerned, that's good.
Okay.
We've done our part.
So as long as you are not communicating via email with a quorum of committee. So you can certainly email it to them, but they can't reply to a quorum of the committee.
Sure.
So if it's all 4 of you, that's not okay because it's not public,
Okay.
so. I don't know.
We should-
So,
It's complicated. 'Cause it's like, I just want to communicate with people who aren't here. So, no, I only emailed it to those two. So, since they're not.
That means we can't even adjourn. We don't exist.
No, you can't.
We don't
you
exist.
You just can't make decisions.
Okay.
You can absolutely hear testimony, you can discuss, you just can't make any
Is
decisions.
that right?
Yeah.
It's funny because I went to a right to know meeting with New Hampshire Municipal Association. They told us we can't even do that.
this subcommittee to order. For the record, I'm Representative Peter Petrino from Hillsborough 23, the town of Milford, and I serve as the clerk on Children and Family Law. Our chairman has asked that I chair this subcommittee on Senate Bill 253 relative to parental access to a minor child's medical records. And before we begin our discussion, does anyone out there have any comments that they would like to make and come forward and speak before this little subcommittee? All right, hearing none. Then what I'll do is I will ask the subcommittee members if they would like to make some comments and speak to this bill. Representative Raymond?
Sure, I'll make some comments. So I'm not in support of this bill. I brought my notes from the last time we discussed this, from the hearing and then our executive committee. And the New Hampshire Hospital Association was opposed to this bill, as were a number of mental health providers and doctors, because they were concerned about two things. One was that it introduces a new standard for abuse and neglect reporting that's inconsistent with HIPAA. Right now, state law says a reason to suspect abuse or neglect. You contact DCYF and you kind of let them do their stuff. And HIPAA, the Health Information Privacy Act, says if you have a reasonable belief that there's abuse or neglect, that's when you either contact DCYF and or consider whether or not it would be appropriate to release records. And then this bill will change that language to clear and convincing. And I just can't get behind making that change because I don't see how that's in the best interest of kids. So that's where I'm at.
Okay, how about you, Representative Nelson?
Thank you very much. I am in support of the bill, but I'm willing to discuss some sort of compromise if we are amenable to that. I do feel that it's important for parents to be able to have access to medical records with certain exceptions because it's their responsibility for the well-being of their child. I know that there was some concern and some discussion in the Senate hearing about access to patient portals and being able to refill necessary prescriptions and have information that would be helpful for making important healthcare decisions that a minor might not be prepared to make. And that's pretty much it.
Okay, thank you very much. So, all right, so I spent a lot of time recently taking a look at this bill in great detail and doing some research, and I have seen that this bill has come up a number of times. Last year we had House Bill, well, back in 2022, we had House Bill 1345, which was essentially the same as the Senate bill before us, and that was interim studied in the Senate. This year, we have a very similar bill, House Bill 406, that is over in Health and Human Services. It's nearly identical to the bill that we have here. That, too, has been retained. The bill before us has been retained. There has not been a clear consensus with these three bills in the last 2 years that convinces me that this is something that really is we should be moving forward with. To be honest, I'm not even sure why we need this bill in the first place. There was a question that was asked of the sponsor. The question was, why do we need this? The sponsor, Senator Innes, said simply, it's a statement that reinforces and reaffirms what already exists. So that in and of itself tells me that all of the protections that parents need to have do in fact exist. And of course, HIPAA is the overriding factor which decisions are made regarding confidentiality. Looking back at the House Bill 406, Representative Colfault simply said that there's nothing in New Hampshire statute that specifically asserts a parent's rights to access. And that's true. We don't, because, once again, HIPAA oversees everything. He cited very specific instances where healthcare providers cannot, under HIPAA, release certain information. So that in and of itself tells me that every protection that parents need to have, in fact, exists. And so the bills that have come before us, this bill here, the House bill, and of course, the bill from 2 years ago are all moot. But all of that being said, we still have the House Bill 406. I reached out to members of Health and Human Services. I sent an email to the committee, did not get a response. I actually made a phone call last evening to 2 members and spoke to them directly, and they said they do not know yet when that bill will come up to their subcommittee. And so I think we can see what they have to recommend. And so at this moment, I have to be honest and say that I'm sorry I voted to retain this bill, but right now I am looking at ITL. Any further discussion on that?
No.
No, thank you.
So we would go forward then. We have 3 out of 4 members, and so our recommendation is going to be to ITL this bill. And without objection, I say we move forward with that and close our subcommittee. We all in favor?
Do we need to take an official vote or do we just go forward?
An official vote would be fine. Okay, so would you like to make a motion?
Sure, I'll move that we recommend ITL. I just want to make sure that Representative Nelson's position is accurately reflected.
Is recorded. Thank you very much for that. Okay, so I will second that, and we'll take a vote.
Oh, we're voting.
Yeah, I guess. No, go right ahead if you would like to speak.
I just wasn't sure. We're gonna vote.
Yeah,
okay.
no, I think that's appropriate since we've made the recommendation to ITL,
Okay.
but Representative Raymond is correct that all positions should be reflected in our vote. Okay, so Representative Raymond?
Yes, I vote yes to
You
ITL.
To ITL. Representative Nelson?
No.
And I will vote yes, so that the vote will be 2-1 ITL is our recommendation. Okay, thank you very much, folks. All right, that was short and sweet.
All right.
Okay, thank you.
Going to call the meeting to order on the subcommittee review of House Bill 535 FN. And previously to our meeting, the information on the bill, and we had some data provided to us through the great work of our Christina Dyer, and was sent to all members for us to be prepared to address what our intent would be in terms of recommendation for action or otherwise on 535. So that being said, I'll open the meeting, and if there's any comments from our visitors here today, just step up to the table and you'll be recognized immediately. So that being said, and take advantage of everyone's time, do we have some comments from our members? Representative.
Thank you, Mr. Chair. I mean, I think we could all agree that there are, that attorneys in some of these proceedings are necessary. You know, and that would be my interest, at least closing out this term, is to get a consensus with both parties that that's absolutely a necessity. And looking, you know, I'd be looking to define in a small way whom we could first get attorneys, require attorneys to get appointed to. You know, then as the terms go on, we could redefine or add more. I mean, of course, this is a fiscal note added to it, so we're coming up with the policy. If the policy is too grandiose, the fiscal committee may not be on board with us, and that would be too bad, because the policy is the policy. So, that's what I'm looking for. So to start on line 14, in all proceedings of judicial branch family division, a minor child who is subject to such proceedings shall be entitled to representation. So I am not in agreement with that. My agreement would be with respect to the family court division, for abuse and neglect children only would be the first recommendation I'd make.
Any initial comments from members? Well, I'll just add one thing, if I may, is, and just in reading the bill, find myself seeing where the word may and shall are present, and specific to abuse or neglect is where the shall comes in, but when that's not there, it has the may, and I mean, for me, that's an inherent contradiction in terms of my term, a holistic approach to the whole case being heard in court, and for the appropriate decisions to be made, so that all information has been presented at the same hearing at the same time. So, and then the concern here is, is this when there is parents coming without representation for themselves, and then de facto for the child? And this could open up a very large, would it not open up a very large cost item that we would need to fund for this? Because as parents coming, just heard in previous testimony, they're on their own when they come to the cases, in some cases in children and family law. But that's what my concern, when I say concern, this may and shall, I don't believe that should be, this should be split up in this case, in what we're talking about here, the Child Protection Act.
Mr. Chair.
Rep. Grossman.
Thank you, Chair. So one thing to consider is we're not fiscal here, we're policy, and to make sure that we're focused on the policy piece. but also to include representation for children that may be placed at a group home or out of in an outside facility, that they are entitled as well to legal counsel. If, I mean, that's in a neglect or abuse case, but that they should have access. If there's a contingency of them being placed outside of into a group home or a child care institution.
Would that be before the fact, or meaning before a court case that the child would already be in residency at a group home, or that would be a determination of the?
I think
court
if it's
action?
determination, if they're going to be going versus, I mean, so that they have representation once they are in there. I mean, currently, right now, we have kids that are not being represented, but going forward, if we have this, they would have representation if there were issues for them.
Any further comments on what Rep. Grossman had to say? Representative Long.
So just a clarification. So, for abused and neglected cases, you would want a shell for any child that has the potential of or has been placed outside the home.
That would be adding additional language, would it not? Specifically, or where would that?
Well, we would be changing on line 5. The court shall appoint an attorney to represent the interest of the child.
Oh, okay,
Guardian.
just the next.
Any recommendation of the guardian on line, yeah, that would have to all change.
We were given some draft language.
Yep. Yeah, actually,
Emily,
if either CASA or the Children's Law Center, Mr. Chairman, I don't know if they could come up and give us their recommendations.
Would you please approach the bench? And if you would just characterize that question one more time, so they can specifically answer it.
So with House Bill 535 language, so we're looking to change this. And lines 3 to 5, the may appoint an attorney representing the interest of a child, but that's just involving all neglected and abused children under the chapter. So Representative Grossman was looking any child, any abused or neglected case that has the potential or actual outside placement. It'll be a shall for attorney representation.
Right. I'm Marcia Sink. I am the CEO of CASA of New Hampshire, and Caroline Delaney, who's seated with me, is one of our staff attorneys at CASA. So thank you for the opportunity to speak. We are supportive of that piece of a child who is in placement out of state. There was additional language that was proposed that would expand that in a way that we feel we would not support, and that is that a child at risk of placement. We currently have in any given year, we're serving about 1,600 children who are in our abuse and neglect court system. And so many of those children are at risk of placement in an out-of-state facility. So it would open up a very broad opportunity for that appointment. We are really supporting a slight change to our current statute in 169C, which would allow broader appointment for counsel. We agree that there are certain cases where absolutely our children and youth need an attorney appointed, and typically for very specific or unique purposes. Severe educational neglect cases, refugee and immigrant cases where we need expertise from attorneys on those types of cases. So our residential out-of-state placements, also, we feel that those kids that were brought to light recently by the Office of the Child Advocate. But we would like to go back to the current statute. What we would suggest is going back to the current statute, providing a slight amendment, which would say specifically that at any point during the proceedings, any party to the case could request the appointment of counsel for a child, and it would be at the discretion of the court to make that appointment. And it's a change in that it currently only allows the guardian ad litem, who the child's best wishes may be in conflict with, or their best interest may be in conflict with what the child wants. And it's only at that dispositional phase of the proceedings, all the child, the whole process for our kids that's the only opportunity for that appointment. What we're suggesting is that we open up that opportunity, that any party could request an attorney at any point during any one of the proceedings. So it could be after the dispositional hearing, when a child is placed in a facility where we think they need attorney representation, or any party on the case could make that request. Does that make sense? I mean, yeah.
Representative.
So just to clarify,
Yeah.
so currently the GAL can request counsel, and that's right now the only component.
We have had other parties make that request, and depending on the circumstances,
Is it the judge's discretion?
it is at the court's discretion, correct. And some of our judges, in fact, when we have requested an attorney after the dispositional hearing, have said, we need one, but the statute currently reads that you've sort of missed that window of opportunity. So this would allow the court to make that determination at any point in the proceedings. We also feel, just to sort of add on that, the resources that we have in the state are so limited. And I know that there is sort of a larger push to have more there are mandatory appointments for our kids, and the potential cost of that and the resources that we would use, we just think could be used for trauma-informed therapists for our kids, or other services that families can access to, potentially help rectify the situation that is at hand. And our kids are so trauma damaged, and there's so many, as we all know, lack of resources to provide to them right now. We'd love to see those resources, that potential resources for appointment of counsel, to be used for other purposes. And I think that the other thing that we see is on some of our cases, when there are attorneys appointed, they're doing an extraordinary job, and others, they are really delaying the process, and permanency for our kids is delayed because of continuances and appeals that are made. So we would just add that smaller piece, but it is a factor on some of our cases. So.
Representative.
Thank you, Mr. Chairman. So you're looking at line 4, where it says recommendation of a guardian ad litem, the court may appoint. You're saying add any party of the case. The court may appoint.
Yeah, we were suggesting just striking where the child's expressed interests conflict with the recommendation for dispositional orders of the guardian ad litem. So that under this chapter, it would read, the court may appoint an attorney to represent the interest of the child in any case brought abuse or neglect brought pursuant to the chapter. So, and just to clarify, our parents on all of our child abuse and neglect cases are appointed counsel if they are the petitioned party. So they do come into the courtroom with an attorney. So.
So if I may ask, is that the current language just specific to the 535 bill and the amendment to 169C 10? Is that, you're in support of the language as presented? Except you're striking part of it?
No, we're not in 535. We're just
Oh, okay, so you're not for 535 at all?
not as it currently reads.
So not 535 at all?
No, sir.
Yeah, I like to talk on how we are today, not what happens tomorrow. But
Oh,
so it's
okay.
like- so it's like right now, as the way this bill is was retained, that language.
I apologize. Okay.
No, I want to make sure, I
Yeah.
want to learn, anytime you speak, I want to make sure I'm learning correctly here from you. The thing, in the notes section, when I say note, the methodology of the 535 bill, I'm assuming you read that.
Yeah,
Section
I
of it.
don't have it in front of me, but yeah.
Oh, that's, well, let's see, just go from maybe memory here, but, where it says that right in here, of the changes, it's doesn't change, it's not really making any change to the court's ability to decide whether or not to determine representation for a child. And what I wanted to confirm for myself is a child is under 18?
Typically, yes. Yeah.
See, typically, and I.
But
Well,
a
There's a moving
child can
target.
extend it, I mean, yes, under 18, but if a child is if there is an open case, a child can extend their jurisdiction if they have not graduated from high school. So some of our developmentally delayed
Yes.
young adults, so jurisdiction can be extended to 21.
Okay, and just one follow on, it was just saying that under the proposed amendment, is that it was still stating that the decision of whether to appoint a child, and I'm just doing the narration here, child and attorney remains in the discretion of the court and is not mandatory, quote, in all cases. And I say in quote to highlight that. That appears, in my opinion, to be where much conflict takes place. Is a judge will say he or she has a dog on Monday and a cat on Tuesday on how they determine who gets representation. And should we have more, or should we not use the word shall more in the evolution of this policy versus the may? What would be your recommendation?
We don't agree with the shall appoint,
Okay.
unless it's really carved out in very unique circumstances.
And would a unique circumstance be a definitive evidentiary proof of abuse and neglect?
We feel very strongly that a child and a child's attorney should not be part of the adjudicatory hearing. At least the initial draft of the language that we had seen was upon the filing of a petition. And the reason for that is, well, there are a few reasons. If you have a child who is, let's start with the child is the victim of trauma, regardless of what's happened in the home. It could be domestic violence, substance misuse, parents' mental health. A child should not be responsible for being part of the process that might throw their family into this system. It should not be the child's responsibility that shouldn't be part of the family history going forward, that a parent might, if a child is being honest about what's going on in the home, that child could be responsible for, wow, now DCYF is involved with our family and the tension that could come from that. In addition, we've got the potential of a child being influenced by a parent to perjure themselves, to not give accurate testimony, or to tell their attorney not to give, don't downplay, don't tell them what was going on in the home. And just already for a child who's undergoing so much. It's so tumultuous and scary that we should not have a child be part of this system. That the adults, the people who have reported and are the witnesses should be the ones responsible. So from CASA's perspective, not having a child have that responsibility. So in terms of the timing of if counsel were appointed for the child, that counsel does not participate in proving or disproving the petition that has been filed, regardless of the child's position. Because a 3-year-old might say, I want to go home. I miss my mom. But you know what? It's not safe. Is that clear?
It's debatable. And, and I'm not trying to be funny, but,
Right.
but that's what this is about, and what, by about, meaning what the subject matter. And I'm just looking here for guidance from our members here is, is this appropriate language where we are, notwithstanding the may and the shall, or is how it's operating now, is that acceptable to, in this case, to CASA?
I think that, as we said earlier, we're not in support of House Bill 535. But we do recognize there's an opportunity within our current statute to expand that opportunity for our courts to appoint an attorney in other circumstances. So we're just suggesting, and again, we're suggesting as an aside to House Bill 535 that there is an opportunity for expand our current statute to be more inclusive and to be able to provide a broader opportunity for our courts to appoint attorneys for children.
And just one last thing, and that statute is 169.
169C, yeah.
Okay.
10.
10. All right, thank you. Representative Long.
Thank you, Mr. Chairman. So in my notes, I didn't hear any nonprofit that was in support of House Bill 535 has written. So it's up to this subcommittee if we want to do a deep dive and completely put in language that's not in here. That would be up to the committee. I don't know where you want to go with that. Like I said earlier, I agree. I agree where a child shouldn't be in the system making, even hearing those arguments with parents and their attorneys. I do believe that attorneys are needed for the best interest of the child. I know CASA has the best interest of the child, but I do feel that I believe that children would feel more empowered knowing that whatever the result, I had somebody who was responsible to take care of me, which I agree with. So, I mean, the more I look at what we're discussing, the change is a total upside down from this bill. And I don't know if this subcommittee wants to get into that discussion to change the bill or wait for legislation to come forward next year or this year or 24 actually to address this. That would be up to the committee. I would say we ITL it, and because there is, in my opinion, too much language that needs a change on this.
Representative.
Thank you, Mr. Chair. I think it's just, now this is different. It's my first time on this kind of committee. We can just discuss things, right? Like right now. So one of the things I think it's important to keep in mind on this may shall language is that when kiddos, abusers will use whatever they can to weaponize, and they'll make it look like they're the victim in the meantime. But coming out for these children, knowing that they're going to have representation, and we're not leaving it up to the discretion of the court, looking at the entire case and how it's going, it actually could be a bigger problem. Because say you have an 8-year-old and you automatically, put them and make them involved in all this, that 8-year-old doesn't know anything different. Like what they have at home is their normal. So it's not like they're going to come out and say, oh yeah, this is abuse. They don't get it. And so it really further weaponizes the system. Unfortunately, I think it's meant, it's in good faith to try to make it better, but it's one of those cases where it can really further weaponize it with that shall stuff.
Representative Long.
Thank you. Actually, Representative Seidel had fantastic questions, and we got great answers. And that's when I was looking at this saying, oh my goodness. You know, so would you agree that, or answer it yourself, the current language needs a lot of change as far as CASA is concerned?
In HB 535?
Yeah.
Yes.
Okay, great. And I would ask the Children's Law Center to come forward and ask if that's the same case. OCA, Waypoint, whomever wants to come up with that same case. And I'm under the impression that the answer will be yes, it needs a lot of change. So it would be up to the subcommittee. Do we want to do the due diligence and get something in this to have it acceptable to us to bring it forward? You know, I don't know if we want to dig that deep into, you know, into fixing this bill. As a subcommittee and then bringing it to the full committee, which they didn't have the opportunity that we're having discussing this.
Well, I'll offer this, and I'm in concert with Representative Long. I believe what this needs is a cooperative collaboration with the intelligentsia that we have, and to have a study committee on this. And the study committee is to give it the time to do a bill that can be vetted appropriately, and, you know, for the nuances. It's not saying, I would say everyone wants to do the right thing the first time, but it's to know what are the collateral effects if, you know, you say open a door, but when, where, and how fast. So it's, that's what I would offer us to consider as a recommending that this bill that a study committee be established on this subject. Representative.
Thank you, Chairman. I concur with Representative Gregg in what she put forward and with Representative Long. And I do agree that we're dealing with children's lives, and I do think we need to look at this a lot more closely before moving forward. So I do concur with you that we should do a lot more research before changing anything. Thank you.
Representative Long.
And a question, I don't know if we could we ask to study for a study commission on, so it would be amended to be a study committee? Or a study commission? I'm not sure if we could do that in the second year. Okay, so this has to be, ought to pass our ITL has amended, or ITL, okay.
Representative Grossman.
Thank you. Is it, do we know if legislation has been filed as well for this current? Are we allowed to discuss that here? If there is are any LSRs that have been filed related to this legislation? Because I think a study committee, I just would hate to keep putting it farther down, hoping that potentially if there is some an LSR currently, maybe we could do some work this session to get it going versus a study committee, which would just take longer for these kids.
Yeah, so there is. However, I'm not sure if the House is going to accept it because we have a bill with the same language. I know I was turned down on a OLS filing because there are bills currently retained that address that subject. So. Okay. Okay. And I absolutely understand the nonprofits. This is an opportunity. Some of us clearly know where we want attorneys. And I get that this is an opportunity and it's exciting that we could revamp this bill to get what we really want. However, the more I think of it, the subcommittee has the knowledge. This is gonna go to the full committee, which they're not gonna have what we have. And I think that would make it more complicated, and I wish to remain on the safe side, to get both parties agreeing, yes, this is absolutely needed, here's where we're gonna start. Then have a battle over this, and not set the policy, in my opinion, where, some kids need an attorney, absolutely.
Anything further from CASA? Thank you very much. Would any, Children Law Center? Yes, Children Law Center, please. Good morning.
I'm the executive director of the Children's Law Center. I think I can probably speak loud enough. Do you need me to? Okay. Okay. So I'm happy to answer any questions. I would say that so the Children's Law Center provides legal representation to children involved in child welfare proceedings and at-risk children generally, but we do provide representation to kids in 169C proceedings. So we have that experience. I take it that the committee is, we are not interested in advocating for counsel for children in other types of family division proceedings. So my comments are just about 169C. I'm not an expert on legislative procedure, but I will say that I do think this subcommittee could work on an amendment that is a relatively robust amendment to the existing legislation, if it felt that it wanted to do the work now and could bring it back to the main committee. This is an issue that should be addressed sooner than later by the legislature. You have made children parties to abuse and neglect proceedings, and as a matter of law, they are also victims, but they are the only party that does not currently have the representation of counsel. Children have extensive legal rights in 169C proceedings. They have legal rights that are afforded to them in the Child Protection Act itself. They have legal rights through 170G21, which is the Foster Children's Bill of Rights, and they also have due process rights, so they have constitutional rights, but they don't currently have a legal representative to advocate for those rights. There are 36 or 37 other states who currently afford children the right to counsel in abuse and neglect proceedings. So there is robust data and research and track records established in other states. I respectfully suggest that you don't need a study commission. We can certainly provide you with research and data, the thrust of which is that the best practices are to provide counsel for children. I'm happy to speak further about other details to address some of what Marty Sink said, if you would like. I think that a fully discretionary, amending the current bill such that, I think this is what CASA has recommended, that the right to counsel would be entirely discretionary. So that's a contradictory statement. It wouldn't be a right to counsel, but the ability to appoint counsel being entirely discretionary, in my view, would not get us very far. Children don't know to ask for lawyers. And so I worry that although a fully discretionary, a judge's ability to appoint counsel in any case is a step further than the way the statute is currently worded. It is a very, very small step. And I think the legislature can do better.
Representative Long.
Thank you, Mr. Chairman. So right from the get-go, we already have conflicts between entities that have the best of children in mind. And I absolutely agree with all of your entities that you do have the best interests of the child in mind. And I love your advice to me. I lean heavily on that advice. So you called for a robust amendment. What are we talking about? 2, 3 pages?
No, I think we've got it down to a page.
Okay. And in your opinion, how much of this current language in here would change? 535. In 535.
So I don't have I'm familiar with I don't have a copy of it in front of me, but I know that it was a relatively minor change to the existing language. The way I see it, there would probably be, if we do a carve out that would provide the absolute right to counsel in certain cases, so counsel at risk of placement, and we could probably drill down on what risk means, that would be additional language. There might be other language that makes provides a path for a child to be advised about the right to counsel, so that might be an extra provision. We also would want to suggest to the legislature for inclusion in this legislation that the attorney have the right to access records. It is currently very difficult for us to access our own clients' records in these proceedings. And so that would be something we would want the legislature to consider. But this is discrete language. I'm just sort of giving you the bullet point list. Currently, the statute allows attorneys, children who have attorneys appointed for them, allows the attorneys to petition the court for funds for services other than counsel. That is money paid through the Indigent Defense Fund. We'd like the legislature to include in the legislation a procedure that allows attorneys to make that request without input from the other parties in the same way that those requests are made in delinquency and adult criminal legal proceedings. So
Okay,
those
so
are some of the bullet points.
Follow up, if I may. I believe there was 5 or 6 changes that's not currently in here.
That's right.
So it may be simple to delete a line, but you're adding 5 or more, which I'm not seeing that there's a consensus on with all the entities that have the best interest of the child in mind. So that's what the complication is, because my understanding is these retained bills have to be out by November 15th or November 17th. And I don't know if the committee as a whole could do their due diligence in all those changes. I understand the urgency. I understand there is language. There's other language in the other 35 states. But again, we're dealing with House Bill 535. And it's up to the subcommittee whether we feel that we want to redo it or, and I'd be in favor of redoing it if it was related to me a little simplified, which I'm not hearing that it is. Due diligence of the full committee, I think would be missing, and I would be afraid that we may not be heading down the right road, and that would be a complication. I personally believe again that we ought to ITL 535 and get bills in for this year through the Senate, to address the urgency.
Ms. Wolford, one question or a comment and ask your guidance. In line 3 on the bill where it said this is in, where it's, the changes on this effort was in cases involving a neglected or abused child only. It wasn't talking across the board. Would that not be a defect in the bill inherently?
Why is that, sir?
Because
I'm not
there-
sure I follow.
Because again, children playing a role in the cases come before children and family law aren't there are those neglected and abused will have that label put on them in that case. But there's also other challenges like that could be taking place, and I don't have the correct legal terms to use. But do we need more of an open description than than what we have here, where it just says in cases of neglected and abused? How about if you're not neglected or abused, but there's other could be medical issues, that dealing with a child, a minor.
Let me see if I'll answer the question the way I understand it, and you tell me if I'm not giving you the answer.
No, I want your
You're-
answer, not what I'm
okay.
telling you it should be. No.
Well, my organization provides representation in abuse and neglect cases, and so that is our focus. Our clients typically are growing up in poverty. There's a very large intersection between children growing up in poverty and the abuse and neglect process. Children in the legislature has identified children as parties in abuse and neglect proceedings, and I don't think that is. I'm not an expert in other areas of family law, so I can't tell you much there, but my impression is that children probably are not parties to those proceedings. In abuse and neglect cases, the caption of the case is the child's name, in the interest of child's name. And so what other states have determined, and what we think is the best practice, is that children who are victims of abuse and neglect, who will have decisions made in their cases which carry out over the course of, well, it should be 12 months, but typically much longer in abuse and neglect proceedings, that children have the opportunity to have legal counsel and legal advocacy in those cases, which will determine the balance of the course of their lives.
Well, that's a debating point. And, I what's debating on it is what is the primary issue that can be proved, by proved, I mean in a court environment, and if it's not necessarily abuse or neglect, I mean, again, that's that particular silo, as I'll call it, but there's medical issues, developmental disabilities, and so on, where they're doing their best, but it's not happening. And they meaning the parents or parent. And it's just looking here, when do they have a court representative for that specialty, and not for a crime per se, but for a specialty? And that, just seeing how broad broader this could be.
Yes, it could be. I mean, that's an access to justice question, probably. I mean, there are many gaps in our legal system where we don't provide attorneys who would be very helpful for people who need them. But this we've identified as a very particular and
Right.
acute need for representation.
Right. I did consider you my access to justice, by the way. So I was hoping you'd provide some guidance in that regard. That being said, when I offer, I mean, I'm just going back on my history. I've been here over 20 years, and in terms of, when I say a study committee, that's just a code word for it needs more work.
Okay.
And I'm one that does, let's get it done while we're young. So it's that to have it done before the end of the term, and it's either a recommendation, for what the wording is, or it's continued for a bill to be filed for the next session in the fall
I see.
of 24. But not for me. I'm not about delayed tactics or any. It's just say we have tremendous assets, you being one, that to help on this, and then but to do it right the first time, and again, that's why I was bringing up the term study committee. so that this would continue. But that's with support of the recommendation of all members here. But I saw that this does need more work, and as Rep. Long pointed out, well, don't have to repeat what the gentleman said. You know, it's work is needed on this, and this is the classic case. It's not ready for prime time, and and I no, you're not supporting the bill as written. Would that be a correct statement?
That's correct.
Thank you, Your Honor. Finally, got an answer of yes from you. But anyway, that was it for myself. Representative.
Thank you, Chairman. So my question would be if there's a way, because we have two wonderful organizations here that are thinking, and what I'm saying is thinking a little differently, but is there a way to find a common area where we can make some changes to move it forward, but still keep it on the table so that we still can add to it? So we're not waiting a whole nother, year or so, but we could somehow find a compromise that's going to meet the needs of the children, and start the process moving forward, and then still come back and think about how could we make this better? Is that a possibility?
I think that's always possible. When we've had discussions with CASA, and I should point out that New Hampshire Legal Assistance is also here, as is the Disability Rights Center. And so we have engaged in those conversations. I don't think it's out of the question that we could continue to have conversations. It is a possibility. We have not yet found common ground entirely.
But not entirely, but at least a starting point.
Well, I think we agree with CASA that a court's fully discretionary ability to appoint counsel is a step in the right direction. We just don't think it's a step far enough. And I think that CASA would say that what we are proposing is a step too far. And so that's where
So we can find that middle ground to start, just to get the ball going and then come back. So we don't end up with something where we're asking too much that's never going to get through.
that is a good plan.
I'm sorry. I'm done.
Did you have a comment, Rep. Greg?
Sorry, got to this one. So I think I think we're all working towards a progressive language and stuff. I just don't think we're going to find it in 535. I mean, it basically is like a gutting of this, of what Representative Huell wanted in the beginning too. So I just think, yes, I agree. We need legislation, and there are ways to go about it that's more amicable, I think. But I'm continuing on with what Representative Long said, that I think this should be ITL'd. I think it just is a full skeleton project at this point, with so far 2 people disagreeing with the language in there.
Anything further, Ms. Walford?
No, thank you so much.
All right, thank you for your time today.
Thank you.
Representative Long.
Thank you, Mr. Chairman. So I see, I believe, where Representative Ball is going. If there's a small bite that we could do, that's not a lot of changes. I mean, I can only speak for myself. I'd be willing to meet 2 or 3 times before the end of October on this subcommittee to get that simple language that could be easily explained to the full committee. And instead of all the gusto that you wanted to add to it, which I'm open to, and I agree that it may be in the best interest. So if we could get agreement with those involved with, something that starts this off, because I think that if we can get a positive policy on this in January, because I believe that's when it would come to the House floor by both parties agreeing, I think that starts us off in the right direction for 24 to get some tweaks. So I don't know if that would be possible, Mr. Chairman, or what the rest of the committee is thinking at this time.
Any comments on Rep. Long's statement? My view is with respect to Representative Long, that I would not want to support that. That's a death of a thousand cuts in my view. And is to do it, now just, I like to walk the talk, let's do it right the first time. And that's why I was recommending the study committee that we really look at the bill at 535 being the vehicle that we can utilize to do something to be voted on before the end of the term. But prior to that, to do like just part of it and then see how it works out, that will be a delay tactic, not by us, but by others in the next term. And this will be continued on ad hominem. And that's why I would ask we not consider that strategy. It's either we do a total revamp of the bill, as opposed to ITLing, which means it's on hiatus until a new bill is generated. But still work has to be done as to how would that bill and the wording of that bill be brought to the table, and collaboratively. So that's where I ask consideration. Rep. Long.
Thank you, Mr. Chairman, and I could agree with what you just said. However, studying House Bill 535 is like I'm going to turn my 63 Dodge Dart that has flat tires, the engine's burnt, into a Ferrari, because this is not the place to start. We all agree that this isn't the place to start. So that's yeah. So again, there's two choices in my mind. One is to ITL 535, or the other one is to get a much smaller agreement with everybody, that the concept of attorneys for abused and neglected children is a concept that we all agree with for the House session in January, which I'm thinking this will be coming up, and then work towards better language as we move forward. So that would be up to the subcommittee. As far as I'm concerned, this bill, I would support an ITL.
Okay, thank you, Rep. Long. Did the disability rights folks have any comment to make, or would like to make any comment on this? Yeah, I wanted to take advantage of you being here, so.
Thank you. I'm Karen Rosenberg. I'm the Policy Director at the Disability Rights Center. I think that Lisa Wolford actually spoke for the group that I'm involved with, the Juvenile Rights Policy Group, and that consists of Waypoint, the ACLU, New Hampshire Legal Assistance, the Children's Law Center. Who am I missing? New Futures. I think I got everyone? Got everyone. And we really think that there needs to be the changes that Lisa Wolford outlined. We need to have a right established for children to have counsel when they're at risk of placement in congregate facilities. Bledsoe is a good example of what terrible things happen when children are sent out of state, and children need to have someone in their corner, an attorney. And we understand that the judge's role is to make a decision about what's in the best interest of the child, that CASA's role is to present to the court about what's in the best interest of the child. It's also in the best interest of the child to enable them to have a voice in these proceedings that really directly impact their lives. So it's a step forward to expand discretion for court appointment, but it's really not what's in the best interest of the children in our state who are at risk of placement at some pretty challenging facilities where they're, even if it's a good facility, they're being separated from their friends, their schools, their families, and to have someone in their corner to assist them is really important. It's also what most states do across the country. I think New Hampshire is one of only a handful that doesn't guarantee a right to counsel for children in dependency cases. So maybe this isn't the vehicle to do that, but we really hope that this committee and that the legislature will fully consider the importance of guaranteeing a right to counsel for really vulnerable children. Thanks.
Okay, what was your full name again?
Karen Rosenberg.
That's it.
You got
I'll
it.
make sure I had it right up. 'Cause it's always Ms. Rosenberg to me. That's
You can call me Karen.
All right, thank you. Anything? Oh, thank you very much, Ms. Rosenberg.
Thank you.
Oh, Karen, I should say. And legal assistance, would you give any comments to what?
I haven't given comments. My name is Michelle Wanger, and I'm from New Hampshire Legal Assistance. And I echo everything my colleagues from the Disabilities Rights Center and the Children's Law Center have said. I think what's really interesting about this issue is there's so much agreement with the benefits that CASA brings to the table. And then there's also agreement that there are in certain circumstances that there really is a need for counsel to bring a legal perspective to the child. And I think there was a conversation earlier about attorneys sort of getting in the way of finding permanency for kids. And I think what's challenging about that perspective is that if a child has counsel, the counsel's job isn't to blindly say, child, you want to go home? That's what I'm going to argue for. That's not what an attorney does. What an attorney does is talk to the child about their perfect world and really flush out what the child wants, why they want it, and then talk to the child about options. As an attorney who has represented kids in all kinds of different juvenile justice cases, one of the most important things an attorney can do is know about all of the options available to a child and then what their legal rights are to pursue those options and then use the law to pursue those options for them. And when a child is in court and they're told that the only options for you are to go home to an unsafe environment or go to a facility like Bledsoe, and nobody knows their rights to other legal options and how to vigorously pursue those legal options, that child is at a disadvantage. So under current Supreme Court law, we think the bare minimum is that there is a full discretionary right to counsel, which must include notification to a child of their right to request counsel. But we think that leaves children at a severe disadvantage to actually access counsel and reap the benefits of legal advocacy to not only pursue their desires, but truly be counseled on the array of legal options available to them and how to move those desires forward. And so that's the reason why we're in support of expanded legislation. We're happy to continue working with CASA to find common ground. There was a time we thought that might be close, and I think things have moved in the right direction, but I'm still optimistic that there is space for common ground, and I hope to continue working through this process with them, ideally this session, either here in this committee or in the Senate. That's all I've got.
Any questions? Representative Long.
So Michelle, do you think House Bill 535 is the legislation to look at?
I was disappointed to hear that perhaps another bill couldn't be brought in this session if that one were to die. But no, I don't think that that's my favored vehicle to bring this forward. If there's another vehicle to bring this forward in a way that isn't years down the road, I would love to look at those options.
Right. So, and just to confirm, you also agree with the urgency of something going through?
I do. I believe that the current law is not compliant with federal law because it does not allow a judge to exercise full discretion in appointment of counsel. And if that were taken on appeal to the New Hampshire Supreme Court, I think that the current law would likely be invalidated.
Very good. Thank you.
Thank you.
Would anyone else like to offer some comments? Oh.
I know we've been mentioned a couple times here today. My name's Alyssa Massio. I'm the attorney for the Office of Child Advocate. we work closely with all of the groups that are here today. We don't sit specifically on that policy group, but we have certainly talked to all of these different groups. After the Bledsoe report, we've also talked with a number of legislators, including Chairman Pearson and Representative Long. I just wanted to mention from the Office of Child Advocates view, we agree with the idea that the court's ability to appoint counsel should be expanded to any point in a judicial proceeding in the abuse and neglect arena, as has been stated here, and should not be predicated just on a conflict with CASA. Beyond that, there are a lot of great ideas in the room. The one that the Office of Child Advocate feels quite strongly about, based on our Bledsoe report, is the need for children in the abuse and neglect arena that are currently in residential placement or at risk of residential placement shall have attorneys. Based on what we saw from that Bledsoe report, one of the boys that were in that facility did in fact have a CASA, and CASA had a very difficult time accessing that child that we believe an attorney would not have had quite the same barriers. And that was a 169C case. So I just wanted to bring that forward, that those are the pieces that the Office of Child Advocate feels very strongly about, that residential placement piece. And we do believe, though, there are guardrails, potentially definitions around what at risk of residential placement could mean. Perhaps HB 535 is not the vehicle. There has been some legislation put forth around our recommendations from the Bledsoe report by the House, and discussions with other representatives and senators as well.
Anything further? Okay, we thank you very much for your comments. Is there anyone else who would like to offer their comments? Okay, we'll just then go.
I think it stops this vehicle, which has been determined by many here to not be the right vehicle, but it doesn't mean that that's the only, thing that we have for this session or whatever. But I do think, back to Pat's, analogy of the cars and stuff, we can't take this clunker in. I just think it's just too much. I think this one has to be ITL'd. I don't think that this is in the best interest of anyone to try to work with this particular bill.
Anything else, members?
Thank you. I respectfully disagree with Representative Gregg. I think that the longer we put this off, the more children are at risk for having greater issue in what they've been going through without legal representation. I think that there is some work that we could do on this as it is to fit what is needed without causing other further issues and further delay. The only concern I have is, like Representative Ball had said, because there's a fiscal note, that we cannot present anything with a fiscal note this coming session.
Anything further? Representative Long.
Thank you, Mr. Chairman. So I'll, if you'll accept the motion, I'll move that we recommend to the full committee ITL.
Okay, all right, then we have a motion to ITL. Do we have a second?
I'll second that motion.
Is there any further comment from members? Then I'll call for the vote. Representative Grossman.
Yes.
Representative Gregg.
Yes.
Representative Long.
Yes.
Representative Ball. And Representative Seidel. And Representative McMahon is no. So in terms of recommending ITL, that is not a recommendation for us. To take the place of that is to utilize Representative Long's suggestion, and that is to have a couple more meetings on this with the attempt of having an amendment done on this bill, and to see if we can be successful this term. And I thought your recommendation was one that is achievable within the timeline that is open to us.
So if I may.
Representative Long.
Thank you, Mr. Chairman. So yeah, I agree that that's possible with this bill. However, it's not the full alphabet. In my opinion, it has to be for the due diligence of the committee as a whole, because this will be coming to the floor of the whole committee at the end of August, I believe. You know, to take a smaller bite that everybody could agree with, I think, you know, I think would be better for my best interest in getting attorneys for children. I don't like the 3-3, and it's a party division. This is not a party issue, and I don't want that perception to be out there. So if we could get the groups together to make some recommendations to us that could begin helping this issue, if that's at all possible, then I'd be willing to meet a couple times to see if we can't get that done. So, is there a motion needed, Mr. Dwyer? Or do we just adjourn to meet again whenever? Right. Okay.
Go ahead, Representative Ball.
I was just wondering if we can request that those who spoke submit their recommendations in writing. A request.
Yes, as you heard Representative Ball asking for the guidance in a written format, and therefore, when we have our next meeting, as I'll say in 2 weeks, just to give time for those who made their comments today, so we can have it emailed to us, and then all members can be prepared so that when we meet again, we'll be fully loaded with the information, and then with what recommendations to make for a amendment to this bill, and then we can take at that time a definitive vote of either recommend the change in the language or to ITL to see if this goal could be attainable in that time frame. Representative Ball? No, Ball, I'm sorry, Representative Long?
Thank you.
She has a very large influence.
Wow, is it, my hair looking that good?
I know it does, yeah.
I like when I heard some of the discussion, for example, it seemed like there was a connection with respect to those that are in placement. However, not those with the potential of being in placement. So, I mean, something that we could grab onto, because the whole, you know, what some entities want, I could agree with that. But I don't think there's the time frame with which, you know, the rest of the committee will have their due diligence in absorbing it. So anything that can be agreed upon, potential language on, you know, crossing out whatever needs to be crossed out, adding whatever you all agree with, you know, I think that gets us on the upper leg with respect to partisan, making it not partisan, and best interest of the child. So that would be appreciated.
Is there a question from the audience? You may approach the mic so if you would, please.
I would just add that we would like we would be happy to meet with a group and see what we can come to agreement on and bring that to the committee. I don't know if you're in agreement with that agreement? Of going back to the table and working with our partners in this and then bringing something forward.
And just.
An amendment, which would be
Right.
which I'm assuming is needs to be in the form of an amendment to 535.
Yes, yes. And that would be our legal assistance, developmental disability, CASA, CASA, and Office of Child Advocate.
Sure.
So, children-in-law as well. So we have those entities, I mean, just getting together, so there'd be some language that can be provided then to us.
I think we
prior
can
to-
make, yeah, sure.
I mean, if it's either it's possible or if it's either possible or not, but let's see if we can
Right.
make something happen. And that being said, would a, what's,
Do you want to schedule another meeting?
that's right. I was gonna see what was rational based on the schedules here. Would it be like 2 weeks from now? That, for us to have a meeting, I mean, again, so we'd have to have the narratives from you so we could have them read and be prepared for.
And if I'm correct, the deadline would be November 17th that you bring this to.
I was looking at,
No.
the
Okay.
So if I may, Mr. Chairman.
Representative Long.
Yeah, so I'm looking at, we do have some subcommittee meetings, CFL subcommittee meetings on Tuesday the 10th. But I only got one, maybe I'm on just that one committee,
Yeah.
subcommittee. The 10th?
Well, before we then get to the date, what would be an assumption of when you would have a document of the recommendation ready to provide to the subcommittee prior to, and then we would meet after that?
I don't want to make the decision for all of us.
Yeah.
But,
Just a guess, but.
2 to 3 weeks.
All right, so would this, then the week of the 16th of October? So during that week, and the
Sure.
question is to see what, if not Tuesday, are you so directing, Your Honor, not Tuesday? Well, we can have a room in the cafeteria, everyone will show up then.
So can we do Monday or Wednesdays? Which is the best day, that rooms are free? Monday, I think? Okay, is everybody good with Monday?
Only on Mondays or just any
No, every the whole day, yeah. Are you guys good with Mondays?
as long as it's, I can do
Monday.
Mondays as long as it's after 9.
Okay,
After 9.
yeah, which it will be, yeah, which it will be,
So Monday, the 16th,
Monday, the 16th.
and for 11 a.m.
yeah, I got a Sununu Youth Center, Service Center Oversight Committee meeting at 10 a.m. on Monday the 16th.
Oh, it's well, to give you a reason to leave.
Are you looking for me to leave, Mr. Chairman?
No, I meant no, leave the Sununu's.
Oh, I see what you mean, yeah. On the 16th? Oh, that's at 2 o'clock. All right, so that's a busy Monday, yeah.
Wednesday then? Well, we have a scheduling.
Yeah, we have
conflict
a
on Monday,
conflict.
Just
The 16th.
just identified. So was it Wednesday, the 18th? No, Wednesday, October 18th, 11 a.m. I'm sorry.
The afternoon? Yeah, we could see if there'd be a room available.
What's that? All right, 1 o'clock,
Wednesday, the 18th at 1?
1 p.m. Wednesday, 10/18.
At 1 p.m. Okay.
And if and then the main point there is for the team to have their written recommendation for language sent to us, and maybe can have a sent. Well, our emails are out there, but to Ms. I think to Ms. Dyer.
Yeah.
And then Ms. Dyer then will make sure she gets it to the subcommittee, and as early as prior to that meeting, so we'd be fully prepared to, as a subcommittee, to discuss with you and have your description of the application of the language, and then we can have a shorter meeting, I would say, for that. Is that agreeable to all members?
Sure.
And that's agreeable because it doesn't happen without you folks making that report take place. Okay, then that's what we're gonna do, and Ms. Dyer, you'll have that formally scheduled? Yes, Wednesday. And, but we will not have the benefit of your appearance.
She's going on.
Significant changes.
No, we don't need, not a replacement, but I mean, if, maybe your written comments on, is to have that. And then that can be we can have that part of our discussion. Okay.
Just one question. Can the courts be involved in this group conversation? Because it has huge impact on them.
Only if it can be appealed.
Yeah, no, absolutely.
Okay.
Yeah.
I think it would be helpful to have their voice involved in this.
Yes, yes, everyone involved. Yes,
And to be part of our committee conversation as well,
you're right.
hopefully. Yeah.
Absolutely.
Thank you.
No,
Yeah,
thank you for
specific to
bringing that.
policy though, not, financial or whatever. No. Yeah, awesome.
Okay.
So do we just close this hearing?
Yes.
Are we in or could we just close it?
Yeah, well, okay, well, with nothing further from members?
No.
Oh, when we, no.
Just working on it on our own and bringing it.
What's taking place is we'll await a narrative from the consortium that's going to be meeting here to give recommendation of language to get it to us prior to our meeting on the 18th on Wednesday, so that we are not seeing it for the first time. We're going to prepare to have to read it and then to have questions and then clarifications with the goal of either approving, or if not, we will have a vote on ITL in the bill. That is the intent, unless there's something contrary to that from members. So we're going to have action taking place based on the work that the professionals can bring to us. And so pending that, if there's nothing further, I will call the meeting at 12:25 to an end, and thank you very, very much for being part of making this happen. Okay. Thank you.